Hello everyone. As 2024 comes to a close, we follow SEO's grand tradition of reviewing the year that went by. The flagship article of our year-ender series is our list of top 10 judgments of 2024. Picking 10 landmark judgments was no easy task, especially because almost 1,000 judgments were delivered this year.
So, our guiding light while putting together this list was impact. We filtered the set of judgments through the lens of the effect they could potentially have on large and critical constituencies such as taxpayers, homeowners, voters, and minorities. Here goes Supreme Court Observer's annual list of the Supreme Court's top 10 judgments.
A judgment that quashed the Gujarat government's order to release 11 convicts in the Bilkis Bano case was the first big decision to make headlines from the Supreme Court this year. The convicts were sentenced for life for the offences of rape and murder during the 2002 Gujarat riots. Notably, the convicts were sentenced in Mumbai, making the Maharashtra government the appropriate authority to consider the remission. The judgment suggests that the Gujarat government was aware of the convicts' mischief of applying to the wrong government and still considered their application. The judgment put on record that the Gujarat government acted in tandem with the convicts. Further, it held that although the decision to release the convicts rests in the administrative domain, courts have the authority to quash remission orders.
In the lead up to the 2024 Lok Sabha elections, a 5-judge bench quashed a 2018 electoral bond scheme. The scheme allowed corporations, individuals, and organizations to donate anonymously to political parties. The court ordered the immediate halt of bond sales and asked the Election Commission and the State Bank of India to publicly disclose the data they had collected on EB transactions.
The Arvind Kejriwal bail saga had the effect of relaxing the stringent interpretation of the bail norms in the Prevention of Money Laundering Act 2002. Kejriwal was arrested by the Enforcement Directorate for his alleged role in the Delhi liquor policy scam. He was also arrested by the Central Bureau of Investigation on corruption charges in connection with the same scam. The court noted that Kejriwal had suffered long periods of incarceration and that the trial in his case was unlikely to commence in the foreseeable future. The court's decision seemed to open the doors for the release of other incarcerated opposition political leaders like Manish Sisodia, K. Kavita, V. Senthil Balaji, and many more. Many of the subsequent orders also refer to the delay in commencement of trial. More than once, the court reiterated the maxim of bail is the rule, jail is the exception in the context of PMLA cases.
In a potentially far-reaching judgment on the affirmative action jurisprudence in the country, a 7-judge bench of the Supreme Court upheld states' power to create subclassification within the reserved scheduled caste and scheduled tribe categories. The majority reasoned that subclassification was permissible to ensure substantive equality, since different communities in the scheduled caste and scheduled tribe list faced varying degrees of discrimination and inequality. The bench, however, held that any law creating subclassification had to be based on empirical evidence and would be subject to judicial review. In the wake of the judgment, several state governments indicated that they were keen to advance subclassification. Haryana was the first to do so, weeks after the judgment. The Nayab Singh Saini-led BJP government approved the Haryana Scheduled Caste Commission report, which recommended a 10% sub-quota for deprived scheduled caste persons in government jobs. Earlier this month, Telangana Chief Minister Revanth Reddy announced that the commission constituted by his government to study subclassification would submit its report. Reddy's Congress government has made it clear that there would be a positive outcome for the Madiga community, which was prominent in spearheading the movement in favor of subclassification in the first place.
2 9-judge benches dealt with the distribution of lawmaking powers between the union and state governments this year. In Mineral Area Development Authority, an 8-1 majority held that Parliament's powers to make laws on mines and minerals cannot be extended so far that it usurps states' power to legislate on the subject. In Lalta Prasad Vaish, in a similar majority, the court found that the union's powers under List 1 of the 7th schedule cannot be used to take away the powers that List 2 has vested in the states. Thus, state governments had the power to regulate industrial alcohol. In these cases, the majority found that a clear division of legislative powers, that is, lawmaking powers between the states and the centre, was critical for maintaining India's federal structure. Interestingly, Justice Nagaratna dissented in both judgments and expressed similar concerns, observing that the union's control on subjects like minerals and industrial alcohol allowed it to take decisions that would prevent uneven economic development across the country and discourage interstate rivalries.
As a result of the Supreme Court's judgment in Just Rights for Children Alliance versus S. Harish, India is now part of a club of jurisdictions which have explicitly criminalized the viewing, storing, and possession of child pornography. The court objected to the use of the phrase in formal context and noted that it should be called child sexual abuse and exploitative material, or CSEAM, instead of child pornography. For years, high courts have been struggling to coherently answer whether mere possession of explicit videos involving children came under the view of the POCSO Act. It also found that the Safe Harbor Clause under Section 79 of the IT Act, which immunizes intermediaries, which you know as Instagram and Facebook, from liability for third-party information, that is us users, does not apply to child pornography. Now, if intermediaries don't take down such material, their safe harbor protection will lapse.
This judgment upheld Section 6A of the Citizenship Act 1955. This grants citizenships to migrants who entered Assam before 24th March 1971. Rejecting claims that the provision dilutes Assamese culture and amounts to external aggression, the court acknowledged Assam's distinct identity and emphasized that Assam's cultural concerns arose from non-implementation of the provision rather than the provision itself. In Assam, where the interplay of migration, ethnicity, and language is particularly sensitive, Section 6A remains both a product of compromise and a flashpoint for debates about identity and inclusion.
In one of the longest pending Constitutional Bench cases in the Supreme Court, a 9-judge bench had to grapple with two significant questions. One, whether Article 31C continued to exist in the Constitution after the decision in Minerva Wills vs. Union of India, a decision from 1980. Second, whether privately owned property was a material resource of the community under Article 39B of the Constitution. On 5th November 2024, a 9-judge bench unanimously held that Article 31C continued to exist in the Constitution. This provision protects laws that advance directive principles enshrined under Article 39B and C against fundamental right challenges. In an 8:1 majority, the judges also held that not all privately owned property was a material resource of the community. Private property could be a material resource if it fulfilled certain criteria like availability, nationalization, and acquisition.
The Supreme Court overruled a 57-year-old precedent set by a 5-judge bench in Aziz Basha vs. Union of India, a judgment from 1967. The court in Aziz Basha had held that Aligarh Muslim University does not have a minority status under Article 30 as it was established through a union legislation, which is the AMU Act of 1920. In November, in a 4:3 majority, the court held that institutions incorporated by a legal instrument can have a minority status if the founder was a person from the minority community. It also put down specific parameters to determine the minority status of any religious or linguistic educational institution established under Article 30. This was also the first time when the Supreme Court in 75 years laid down such indicators. The parameters will assist a smaller bench later on in determining whether AMU is a minority institution or not. It will also be useful in determining the minority status of various other institutions across India.
In September, the court issued detailed directions to curb bulldozer demolitions nationwide. The court ruled that bulldozer demolitions of this nature infringed fundamental rights such as the right to shelter, diluted the separation of powers by making the executive judge and jury, and undermined the rule of law. The bench also laid down some procedural guidelines: a written notice to be served to the owner or the occupier at least 15 days ahead, keeping collectors and district magistrates in the loop about notices, and ensuring personal hearings before a designated authority. It also held that the ground level government officers would pay money or fines from their own pockets if any of the procedural guidelines are violated.
And with that, we conclude our roundup of the top 10 judgments of 2024. Let us know the cases that you think were the biggest this year in the comments below. And do tell us if you can think of a case that should have been on our list.
And don't forget to read the article of the top 10 decisions on the website where we discuss the cases in greater detail. We've also got other stories rounding up the Supreme Court's activity in 2024.
As we wrap up this video, we want to take an opportunity to thank all of you, our wonderful viewers and readers who support our work every day. Keep following scobserver.in for courtside reporting on key cases that matter to you and me. Thank you for watching and have a happy new year.